Sir Rick here, reminding you to tune in to our new segment called The Sledgehammer, featuring those who make a legal difference in our industry.
All right, and we are back here on BCB Live. What's going on, Brandon? How are you doing today?
Hey, Dave, doing well. Thanks for having me.
Hey, absolutely. What do you think of our new little intro there for you legal?
I like it.
Did you?
I like it. Though I got to say, in Indiana, I don't know if you have this in Texas, but we have a plaintiff's attorney who goes by the Hammer. He's called the Hammer, and he's got billboards up all along the major interstates all across the country. So I want to disassociate myself with any kind of reference to a hammer.
So let me just tell you, I drove a truck for a long time, Brandon, and where we got it from, number one, was my CB handle was Sledgehammer.
Okay.
So just so let you know, putting the hammer down on getting the information out there about information. Yeah, we have one of those too here that uses the hammer here in Texas. So
yeah,
I
think every state has one.
They do. They all have this state. All right, so let's talk a little bit. So Atri study from 2 years ago reveals that 8-figure jury verdicts against trucking companies are skyrocketing.
Yep.
8-figure. Now, we're not talking 6-figure or 7. We're talking 8.
8 and 9. So we just had the first ever $1 billion jury verdict earlier this year in Florida.
I saw that.
I think we talked about this maybe last time I was on, but yeah, some of the numbers are just crazy. Obviously, these types of cases, they're known as nuclear verdict cases. They're definitely on the rise, as the Atri study tells us. And so I think the interesting thing is what is contributing to these types of nuclear verdicts. I think that's something that we could get into today.
Yeah, I'll tell you, look, there's a couple of things. Number one, Brendan, I will tell you that if a trucking company is out there and doesn't need to be there and needs to go away, and is being gross and neglected, that we don't want them in the trucking industry. We don't want them here, and I understand how those punitive damages can pile up, especially if it's one thing right after the other. But here we are, Brandon. Let's be honest. A lot of these verdicts are just out of control on simple wrecks, on things that have very little to do, right? I mean, we're talking about just a bump in the road, and they turn into Nightmare on Elm Street, don't they?
They do, and the issue with a lot of these cases is that, as you said, the awards, the monetary awards in those cases just don't line up with the damages sustained in the accident. I don't think there's anybody arguing for the fact that injured plaintiffs or the families of injured plaintiffs aren't entitled to something in these cases. They should be made whole the best we can through monetary damages. But I think the issue that we have, a lot of us in the industry, especially on this side of things, is those situations where we're talking less about the circumstances of the accident at hand and what the injured plaintiff or his or her family is entitled to. And then we start getting into things like the carrier safety history and things that don't really directly relate to the accident at hand. And that tends to be, at least what the Atri study talks about, it's that type of tactic that leads to these multi-million-dollar and billion-dollar jury verdicts. And that's where we start to run into issues, and that's what tort reform is aimed at.
Yeah, here we are, and we would call that I almost an abuse, almost a litigation abuse, almost of not doing it right for the right reasons. There's no equity in these verdicts when you're awarding tens of millions of dollars for no injury but an accident. I mean, it doesn't even that doesn't even make sense. I mean, it doesn't even compute.
No, it doesn't. And you're not the only one to call it lawsuit abuse. I mean, that's one of the driving forces behind a lot of this tort reform. And, it really, unfortunately, benefits the plaintiff's attorneys more than anybody else. They tend to be lining their pockets with these multi-million-dollar verdicts. And, it's all kind of centered around this reptile theory of litigation where we paint the motor carriers involved in the accident as bad actors, and we try and inflame the jury and get them mad at the motor carriers so that they will take some sort of action to punish the motor carrier for things that may not even have anything to do with the accident at hand. I mean, that's the problem with these cases, is is that, our judicial system in the United States is really kind of focused in on a controversy between two or more parties. And the controversy in these highway accident cases is the accident at hand. The carrier's reputation, its safety-related reputation, should not be on trial. That's not what we're trying to address in the litigation. It's the circumstances of the accident. And so when the jury starts to hear things about the carrier's high CSA scores and their out-of-service rates and hours of service problems in the past, things that have nothing to do with the accident at hand, the only thing it does is it serves to inflame the jury and get them mad at the motor carrier and want to punish them by imposing these multi-million-dollar verdicts.
Yeah, and Brandon, it's what really fascinates me or tries to, what I don't understand. I don't know if it fascinates or sickens me, but in all honesty, we all ultimately pay for these large these large claims. I mean, I don't know how to explain it any better than if these huge cases continue to happen and go unabated, we ultimately are going to suffer with higher prices in delivery, because nobody can afford the insurance if there is no way to protect anyone out there running the roads.
Yeah, well, it's pretty clear what the results are from these types of cases. I think ATRI has done other studies that have shown the significant rise in insurance over the past several years, due in large part to these verdicts that we're seeing. And so those rates, as you say, Dave, eventually get passed on to the consumer. And then obviously the trucking companies involved. When we're talking about $1 billion verdict, obviously the plaintiff in that case is never going to collect $1 billion. There's not $1 billion to be collected. So essentially what happens is those trucking companies get put out of business, and that's how we go. So ultimately, to your point, Dave, it eventually makes its way back to the consumers.
Yeah, I mean, we all ultimately pay. And look, nobody here, in all these discussions that we've had, no one wants anyone not to be taken care of involved in an accident. I mean, that's not where we're talking about equity. We're talking about making sure that if something's done, that we make them whole again. But here we are. So here in Texas, Texas has joined the ranks, I would say, on a common sense measure to ensure that the plaintiffs can't keep doing this with House Bill 19. And I think that's something that Texas has done here in my state. We passed it. Now, it hasn't we passed it, but because of all the other cases, it really hasn't come about yet, even though it's on the books.
Yeah, that's my understanding as well. House Bill 19 was a bill that was passed, I think, early last year, 2021. It essentially it's a form of tort reform. Essentially what it does in Texas, as I understand it, is it kind of bifurcates a highway accident trial into two phases. Normally, a jury gets to hear whatever evidence the plaintiff wants to put on during their case in chief, and then it proceeds to the jury to make a decision. But with House Bill 19, the idea is that going forward, we're going to separate the trial out into two phases. The first phase is going to be aimed exclusively at determining whether the motor carrier and its driver are at fault or not. And in that first phase, the jury doesn't get to hear anything about the motor carrier's reputation, its CSA scores, the other types of safety-related things that aren't directly relevant to the case at hand. And then only if the motor carrier and the driver is determined by the jury to be liable in that first phase of the trial, would the plaintiff then be entitled in the second phase to then talk about the motor carrier's safety history and that type of stuff. So you can kind of see what it's aimed at doing there is it's aimed at getting away from or moving that inflammatory evidence into a second phase so that it doesn't spoil the first phase where we're just talking about straight liability.
Yeah, for a long time we couldn't even show photos of an accident. You can't even show that it's just a scratch. All they can say was, well, they ran into the car and created damage, and there's pain, and you don't even get to show that. Well, you can barely see the tiny scratch on the car. We're not even been able, but now they're starting to demonstrate and utilize that. That there are many rural areas still won't allow those photos to be shown.
Yeah, and I think that's another thing that House Bill 19 does. Again, as far as I understand it, it kind of lifts that veil and lets trucking companies show some of the damage. Because what we're having is situations where the photos, if we were to show them, show barely a scratch on the truck, even though the resulting damages are significant to the other party. But the idea is, hey, let's at least give the jury the full picture here of how serious of an accident this actually was based on the photographs.
Let me ask you a question. How are now? I know Texas has done that, and this is a good proving ground for how this is going to play out over time. How are we? How are we able to put this into a federal type tort reform instead of this whole state by state and action by action? It would be really good if we could get a federal type law into place here on this, wouldn't it be, Brandon? Don't you think?
Yeah, it's difficult from what I understand. These types of administration of the judicial system is kind of left up to the states in how we kind of look at federal and state relationships in our country. And so when it comes to administering how we're going to let the flow of these cases go, that's always traditionally been something that's been left up to the individual states to tackle. Now that leaves open the possibility of what we have today, which are these areas that pop up, which we call judicial hellholes, where things just run amok. Texas has historically been known as a judicial hellhole for the reasons that we've already talked about. So that's the risk you run when you leave it up to the states to handle this kind of on a state-by-state basis. So if we were to get some kind of federal legislation on this topic that kind of levels the playing field from state to state, I think that would be great. Whether that's likely to happen, I'm less optimistic about it.
I will tell you, I think one of the things that we talk about, Brendan, I think it's important that trucking companies and anybody in this industry get involved in their trucking associations, right? And lift up a voice, because I think it's important that the state houses and the state legislatures, and they realize just how many of their constituents are in this industry. And if they want to stay elected, it's important that they hear our voices, right?
Yeah, that's right. And Texas is the perfect example. We do our own podcast for Trucksafe, and we had John Esparza, who heads up the Texas Trucking Association, on last year, and he was on talking about HB 19 and what the association was doing to get that passed at the time. So they were very active in that regard, and they got it across the finish line. And I know that there are other states whose trucking associations are working towards something similar. So being involved in those associations, you can clearly see Texas as the example, very beneficial to the industry as a whole, and clearly effective.
I'll tell you, here we are. How are these laws affecting our the way DOT looks? I mean, these cases. Ultimately, we have to turn around and look back at ourselves, right? At our DOT compliance, what we need to do, and what we need to do to shore up our positivity. I mean, to shore up ourselves against these, right? I mean, herein lies, we have huge corporations and financial institutions backing these lawyers to just go after trucking companies. What do trucking companies need to do to better themselves to go forward?
Yeah, that is the other thing. It's become so lucrative to prevail in these cases that a lot of the plaintiffs' attorneys who prosecute these cases are being backed by big corporations to pursue this type of litigation, which is just crazy. So aside from tort reform, though, to your question, Dave, is what do we as motor carriers need to be doing to guard ourselves against these types of verdicts? There's several things that we can do. I think the biggest piece of advice I can offer, and this is something that we help a lot of our motor carrier clients with, is to be proactive in your analysis and of your review of your safety programs. I don't think enough motor carriers take the time to really dig into their data, to their safety-related data, and figure out where their gaps are from a compliance standpoint. If we look at that ATRI study, they had a list in that study of the top issues involved in those cases that end up being multi-million-dollar verdicts. And it's the common suspects. It's hours of service violations. It's log falsifications. It's drivers driving without the proper CDL. Those types of things. Those are all things, if I'm a motor carrier, that you can catch before you get involved in one of these significant accidents just by watching your data that comes in. You have your access to your safety measurement system, which is the DOT's way of tracking all your roadside violations. So I always recommend that at least monthly that you go into that system, check out what violations did I incur this past month, and start to chip away at those things. The ones that are causing the most problems for you, start to deal with them ahead of time so that you're not trying to put out fires after the fact.
Yeah, and to your point, it might be even good to have a third party come in and look, right? I mean, because it's hard to look. You do it all day. You're in and out all day. You look at your same stuff all day. It probably wouldn't hurt, right, Brandon, to have someone else that with an expert to come in or a consultant of some type, right, to be an outside, be a little bit more objective and do a mock. Maybe a mock audit or something like that?
Yeah, we do a lot of those both through our consulting company and our law firm. The benefit of doing it through the law firm is that, when we come in and we're simulating a DOT audit. But the benefit of doing it through the law firm is that we're not just looking at it how the DOT would look at it. We're also looking at it through the eyes of a potential highway accident litigation, and we can really nail down where are you susceptible to heightened damages in that litigation? Where are you susceptible to DOT enforcement, whether it be civil penalties or a downgraded safety rating? So doing those through the law firm, the other benefit is that when we put together our report noting all of your deficiencies and where you could improve and how you could improve, that report is not going to be discoverable because it's going to be protected by the attorney-client privilege in that context. So we do a lot of those, and I think they are beneficial to our clients in kind of, again, being proactive at identifying the gaps and then working to close them.
Brandon, I like the idea also very much so of what you said of having a law firm do it because then it isn't discoverable, right? Nobody can subpoena that information because it's attorney. I think that's fascinating way to look at it and a great way to take it to the next level. Hey, so what are some of the things that you find that are shocking to the carrier that you seem to find on a more regular basis that the carrier goes, well, I had no idea or I wasn't sure of it that much? I mean, obviously you see some of the many things repetitive, but where is it that as a carrier I just didn't look?
Well, not necessarily that I just didn't look, but the thing that always surprises the carriers that we come in to look at is kind of when you look at how the DOT does their audits, there's a whole methodology that they follow when they do those audits, and there's a whole scoring system that determines what your safety rating is going to be out of that audit. And what a lot of carriers don't realize is that there are essentially 6 factors that the DOT is looking at when they come in. It's going to be driver issues, it's going to be general compliance, it's going to be hours of service, vehicle maintenance, accidents, and then drug and alcohol testing. But what carriers fail to realize is that the hours of service factor is the only factor out of all 6 of those where any violations discovered in that factor are double weighted. So the impact of that is that a carrier under that methodology cannot get out of a DOT audit if a critical or acute level violation is discovered in the hours of service factor with anything better than a conditional safety rating. So what we find a lot of times, every carrier's got some level of hours of service problems. There's no carrier out there that has no hours of service violations, at least that I've looked at. What you have to do in the hours of service factor, though, is you have to stay on top of that, because the minute you start to get a pattern of noncompliance in the hours of service factor, if the DOT comes in and finds that same pattern, it's going to be an automatic conditional safety rating, if not an unsatisfactory safety rating. So I would say hours of service, for that reason, is the biggest issue that we discover in the audits that we conduct.
Wow. It's very interesting. Brandon, I know you do a podcast. Why don't you tell us a little bit about Trucksafe? I don't want to leave that out. I mean, that's why you do so well when you come on here and you join us and you talk. But tell us a little bit about Trucksafe and what it is and what it means to you.
Yeah, so I started Trucksafe a couple of years ago, and the whole idea was to build out better educational materials for the folks that are charged with running a regulated trucking company. One thing that was always lacking whenever motor carrier clients would come to me, they would ask me for a resource for training for their safety managers on what it takes to be compliant with the hours of service rules. What kind of records do we have to have on vehicle maintenance, drug and alcohol testing? I just never had a great place to turn them. I mean, we certainly, there's no shortage of great educational materials out there for drivers, but there just wasn't anything like that I felt I could turn them to help with the management of their compliance programs. And so I spent the first 6 months or so starting Trucksafe, just building out my own kind of curriculum for safety managers specifically. And so that's one of the main things we do through Trucksafe is we offer online courses to safety managers going through the nitty-gritty of the DOT safety regulations and what it takes to stay compliant with those, to not only stay out of the crosshairs of the DOT, but also out of the crosshairs of the plaintiff's bar in highway accident litigation. So that's a big thing. Education, we put a ton of content out there. Aside from our courses, we're constantly posting content on YouTube and LinkedIn. And we also do, as you mentioned, Dave, our podcast. We do a monthly show called Trucksafe Live, where we bring on guests like John Esparza to talk about the hot button issues impacting motor carriers. So we've got a lot of stakes in the fire, so to speak, and really enjoy doing it.
Wow, that's awesome. And I look forward to seeing your next episode of Trucksafe. And if anybody wants to get or listen to Trucksafe, they can listen to that on LinkedIn or where they gather their podcasts. Is that right?
Yep, that's right. Any of the social media channels, or wherever you get your podcast, or if you want to check it out, go to trucksafelive.com.
Also, you are also a partner in Childress Law. Is that correct, there in Indiana? And if anybody needs to contact you about doing any of that other stuff, litigation, or anything that they need some help with from an attorney, they can definitely contact you, right?
Yeah, hit me up on LinkedIn, or you can find my contact information at trucksafe.com. We have a related company called Childress Law, where we practice law in this niche area. All we do is DOT compliance, legal work. So get in touch.
Thanks a lot, Brandon. Hey, man, before you get out of here, I always ask our guests to state their name, who they're with, and that you're watching BCB Live, the safest station in the nation. Can you do that for me?
Sure. Hey, this is Brandon Wiseman, Trucksafe and Childress Law. You're watching BCB Live, the safest station in the nation.
Thanks, Brandon. You sound pretty professional doing it. Almost better than I do. Have a great day.
All right, see ya.